Hello and Happy New Year. It is December 31st, 2025, New Year's Eve. And Pete and I wanted to come on and give you guys a overview of everything we've experienced in family court and in the national movements in 2025. Because, man, it has been a year.
Yeah, that's for sure.
So we're going to start off with January. So January of this year, I started out with a new judge in Florida Circuit 7. I originally had Stasia, however you say her name, Warren, from August 2023 until the end of last year, 2024.
Yeah.
And Pete, what caused me to have a new judge starting in January 2025?
Well, it was very suspicious after, in November, Judge Warren signed a contempt order against you, even though in the hearing she said she couldn't find you in contempt. Mm-hmm. There's the Justin's attorney just, gave her a proposed order and she just blindly signed it. You then filed a Freedom of Information request with the court.
Yep.
And you got some interesting stuff back.
Yep. And I want to talk about that for a second. I want to give a shout out to Liz. Liz is the reason why I knew to do that public records request with Florida Circuit 7. I connected with her in her small Facebook group, and thanks to her, I knew exactly who I needed to email to request any public records in Florida Circuit 7, communications between the judges, the attorneys, external communications. The only caveat to that is you have to actually provide them with the emails and or phone numbers of the person. So if you don't know their email, the request is not as broad. So I had filed a public records request right after that November 19th, 2024 contempt order that Stasia Warren signed with Serena Baldacchino of Rice Law Firm that has wreaked havoc in my life all of 2025. So right after Warren, who is no longer on the bench because she was forced into retirement at age 75 this year, right after she signed that, and then 2 days later, I get an email from Paige Russo at Rice Law Firm saying, we never were able to open your financial affidavit and documents, so we need you to provide that to us.
Which is really weird, because for them to find you in contempt related to financial matters, but the court and the other attorney have not reviewed your financial affidavit, that's kind of suspicious.
Yeah. So I used the information that Liz taught me to my advantage, and I put in a public records request with Mark Weinberg of Florida Circuit 7. And wouldn't you know, less than 12 hours after I submitted that email to Mark Weinberg, the very following morning, Stasia Warren is recusing herself from my case towards the end of December 2024.
And just so everybody knows, that what the nature of that public records request was, you were requesting all communications, email, phone communication, everything between a number of parties and the judge. And the court itself and a number of parties. Basically, if any of these particular emails that you listed out showed up in any official records, you wanted copies of them.
Yeah. I put in a very long email request, pretty much everyone I can think of, including imserlick@gmail.com. Mary and Ira Serlick's emails, as well as a bunch of Laura Stiles emails that I have access to, because she loves to send me emails from a plethora of different aliases.
Yep.
So it was, I believe, December 21st or 22nd that Stasia Warren recused herself. And then that very following week, right after Christmas, I was reassigned to Judge Sandra C. Upchurch in the Daytona courthouse. My first hearing with Sandra C. Upchurch was on a motion for emergency child pickup. So basically, at the beginning of 2024, so just over a year ago, I had been given access to all four of my minor children's grades.
Almost 2 years ago.
Almost 2 years ago. Through my previous attorney, Rick Brown, I was able to gain access to all four of my minor children's grades in Volusia County schools. And what I saw when I pulled all of their historical report cards was absolutely shocking. 1.0 GPA for years.
Just a downhill spiral.
Yeah. Extreme unexcused absences, etc. So there was very clearly a pattern of neglect and abuse happening in Justin Serlick's home with my minor children.
Look, I mean, anybody out there, one of the first signs of problems in the home is children and how they're doing in school.
Yeah.
It's sort of one of the very first signs. Social workers look out for it.
They should be.
Or they should be in the school. But we found out here in Florida,
Volusia County Schools does not care about the children.
Close their eyes.
Yeah.
And close their eyes, close their ears, pretend it's not happening.
As soon as I got access to their grades and records, I immediately started emailing each individual teacher for my children, the individual assistant principals and principals, as well as the school board. And wouldn't you know, Volusia County Schools has been ignoring me since I gained access March of 2024 through my attorney, Rick Brown. Yeah. So it became incredibly evident that my children need help and have a lot of issues. So I, along with that emergency motion for pickup, which is a 12.941D motion, you can find it on Florida Supreme Court's website, I submitted over 80 pages of evidence of the report cards, the unexcused absences, the suspensions, etc.
Did we have the police reports at that point?
No, we did not.
Okay.
No. We got the police reports later after I did that. So January 8th, I had my very first hearing in front of Judge Sandra C. Upchurch with this motion for emergency custody. And her immediate response to that 12.941D is,
I'm not familiar with that statute, so therefore I'm just going to deny this. Mm-hmm. Even though I'm sitting in front of a computer and I could look it up, we're just not going to.
Yeah.
And then 1 month later, we know somebody else that we've connected with, Upchurch, actually signed a
12.941D.
Yeah, one of those, and stole this other lady's daughter.
Yeah. So that's how my year started out. So I knew pretty much immediately in that very first hearing, January 8th, especially since Mary Serlick, Ira Serlick, and Laura Stiles were sitting directly behind my ex-husband, Justin Serlick, in that courtroom.
Snickering the entire time.
That things were not going to go the way they should according to Florida law and U.S. law. So I pretty much knew from the very, very beginning of this year that I was dealing with collusion, corruption, and bribery. Quite literally at the exact same time that I got this January 8th hearing, I also got an email from Florida Circuit 7's Joshua Griffith.
Oh, we found some more emails that might have been part of your request. We just found them. They were under the rug or something. So here they are.
Yeah. So about 3 weeks after I submitted my initial request with Mark Reinberg, Joshua Griffith emailed me with a few other pieces of documentation that Mark Weinberg just conveniently forgot to put in the packet.
And I know we've mentioned who he is before, but the email you got with the additional emails came from the general counsel for the court itself. So not an attorney that works within the system, but the actual attorney for the court, because they knew they messed up.
Right.
And they were trying to CYA.
He definitely was trying to CYA. But in that email from Joshua Griffith was a email that my first attorney, Mary Jane Nettles, memorialized that Michael G. Nurheim from Illinois Circuit 19 called her personal line
which is a violation of the law.
His personal cell phone number,
which is ex parte communication,
to Judge Stasia Warren of Florida Circuit 7 Daytona and Serena Baldacchino of Rice Law Firm for Justin Serlick.
And in any family child custody case between states, it is actually the law in all 49 of the 50 states. All communication between courts must be on the record. You can't make a phone call to one party and who else, who knows what else went on. But unnerved Heather's attorney so much that she wrote an email and emailed to the court. And that was the record that we were able to get.
So literally at the same time that I'm in front of this new judge for the first time at the beginning of this year, at the same time, I'm being given an email proving my suspicion was correct. There is bribery involved. There is collusion involved. There is corruption involved. And
stuff is happening behind the scenes.
Everybody is going to be thrown under the spotlight in this next year. So that's how 2025 started. So I knew from the very beginning that I was dealing with illegal activity. So what did I do? I got louder.
That's to say the least.
So in February, I had filed another motion for reconsideration, and then I filed my first of 2 disqualifications for Judge Upchurch because, like I said, that January 8th hearing, it made it so incredibly obvious she's working for the Serlicks.
Well, especially when a judge sits there and says, oh, I'm not familiar with that law, which is specifically a law related to child custody and family court. And the judge also doesn't take the time to look it up on a computer that she has full access to.
Right.
That judge is not qualified to be a judge.
So along with the emergency motion for minor child pickup, I had also had Rick Brown earlier in 2024, before he just dipped out and served me up on a silver platter to Serena Baldacchino. I had him file a few other things. For example, motion for temporary time sharing, modification of child support, and a whole bunch of other things that just sat in all of 2024. So I stood my ground on January 8th, and I told Upchurch that I have a right to have a hearing in regards to the other motions that have been sitting since July of 2024. So she referred that to General Magistrate Alexander Alvarez of Daytona,
who is also barely qualified to have that job.
I don't even think he's qualified, to be honest. He is a complete moron. So February 10th, I subpoenaed Pete Arnold and my chrysalis therapist, Karen Edward. Karen had not only witnessed a lot of the Volusia County Schools BS, because I was sharing my screen and showing her my children's 1.0 GPAs, unexcused absences. It alarmed her so much that she put in a Florida DCF complaint into the system as a licensed therapist.
She was required by law to report what she was seeing because it was that atrocious.
Yep. She also tried to do a wellness check with the Volusia County Sheriff's Office, to which, even as a licensed therapist, Volusia County Sheriff's Office refused to do a wellness check on my children that were missing from their high school for almost 2 weeks straight.
They literally hung up on her, and it's all recorded. We have the recording.
Yep. Karen recorded it for us. So I subpoenaed her because she has been a witness to all of this since 2023. She had been my therapist from April of 2023 until December of 2024 last year. And then I transitioned to a local therapist here in Volusia County. So I had subpoenaed her and Pete February 10th for the February 25th hearing. And when we got to February 25th, do you recall what happened at that hearing?
Yeah, the Judge Upchurch said she does, or was that not the one where she didn't know? Which
this
one
was with Alvarez. And so Alvarez was blocking my court watchers and trying to push forward with my hearing without cart services.
That was the short one. That's right. You had put in the ADA request for cart services. They were not functioning, and he kept asking you questions and kept trying to proceed, and you kept saying,
not without my cart services.
We're not doing anything unless the cart services work.
You're violating my federal ADA right now.
I mean, you had to push back so hard before he got the message that he was violating federal law.
Now, the sad part is I have court watched for others here in Florida as well as in other states across the nation. And there have been times where the judge knows that the person needs cart services and wouldn't actually allow the hearing to proceed without the cart services working. So other judges actually advocate for those cart services because they know they're federal ADA protections.
Yeah, so there's there's part of the Constitution. It's called the Supremacy Clause. The ADA is federal law. That means it supersedes all state laws, all local laws, all court rules. So you literally, it is against federal law to proceed with a hearing when somebody has requested an ADA accommodation, and that accommodation is not being addressed.
Right. So that February 25th hearing was continued to March 25th. So now we're in March of 2025. That was the second hearing with General Magistrate Alexander Alvarez. And the report/recommended order is dated March 25th with the heard on dates February 25th and March 25th.
I think originally that was only scheduled to be a 30-minute Zoom hearing.
It was almost 2 hours.
And it was
actually, I believe it was scheduled for 1 hour, and it ended up being almost 2 hours.
But it was on 4 or 5 pending motions.
Yeah. And they knew from the very beginning they were going to deny all of it. So
it's certainly what it seemed. There was, look, I mean, as an observer to all of this, literally you have one party submitting, and that's Heather, submitting documentary evidence. So this is, not just, Heather's, what she says, but submitting copies of the report cards.
My exhibits for this March 25th hearing was over 300 pages.
You had the police reports at that point.
And I had the police reports. And let's not forget, I was still filing in person at the Daytona courthouse at this point, and lo and behold, I gave him this massive stack of evidence that needed to go in, and it never showed up in my docket.
Nope.
So never. 2 days before, I outsmart them because it's very clear someone at the clerk's office in Daytona
preventing the evidence from getting submitted.
Was not filing the massive stack of evidence that Justin Serlick is neglecting and abusing my children. And so I outsmarted them and just e-filed it, and then it got into my docket that way, like 48 hours before the hearing.
Yeah. So, but again, you have 300 pages of documentary evidence. That's, report cards, police reports. It's everything a parent who doesn't have contact with their children can get. And it's substantial. I mean, it's the grades alone for 3 of the 4 children, the grades and attendance record alone speak volumes.
Absolutely. How a child does in school is a direct reflection of their home life.
And then you add on top of that the police reports where, there was an event that happened with your oldest son, and that event was never reported to the court. It was you were never told about it. And that was that alone says, okay, one parent is clearly trying to hide and conceal what's going on.
Right. And I want to back it up a notch because 4 days before this March 25th hearing, March 21st, 2025, does that date ring a bell to you?
It's been a long year.
Okay. That was the date we started the podcast. Oh. And how did we start the podcast?
So the podcast that you're listening to now and seeing us, it started. 2 Volusia County Sheriff's deputies came knocking on our door one day. As soon as Heather opened the door, they grabbed her, pulled her outside, and said she was under arrest. They had a writ of attachment for...
they refused to tell me why they threw handcuffs on me. They literally pushed their way into our doorway, so into the house, and this is verified by camera footage, threw handcuffs on me without even telling me what they were doing there and why they were putting handcuffs on me. I start freaking out because I have no idea what this is about. And it wasn't until they got me halfway down the driveway to the squad car while I don't even have shoes on, and I'm in a full-blown panic attack at this point, that they informed me that someone emailed Sheriff Michael Chitwood, and shit rolls downhill. And that's how I started to figure out it was for a writ of bodily attachment.
Originally, they didn't say they emailed the sheriff. They just said someone
called.
somebody called the sheriff.
The one officer, the one deputy said someone called, and then when I recorded them after they took the handcuffs off,
someone made an email to somebody
emailed.
And shit rolls down.
Yeah. And the whole video of that interaction after they took the handcuffs off me is on the podcast. It's on my YouTube channel.
That was Heather's first live, essentially.
I went full-blown live. It is very emotional. It is very traumatizing to just watch that video, because that is in the moment. You guys are seeing me in the moment, how bad this abuse and harassment is from Mary, Ira, Justin Serlick, and then their little pet Laura Stiles with all their legal connections. Yep. It's like they have no clue that there's this thing called the U.S. Constitution that protects U.S. citizens from shit like this.
And it's also like they don't realize that there's public information laws in the state of Florida, because when the deputy mentioned that somebody communicated with somebody high up, that wasn't sitting well with us, and you filed more information requests, and
got a lot more information.
We got some interesting emails.
Yeah. So literally 4 days before this March 25th hearing, I was harassed and traumatized over $1,000 purge payment stemming from that illegal contempt order November of 2024. So fast forward to April 2025. April 2nd, docket reflects the order adopting the general magistrate's recommended order, which was denying or dismissing all of my 2024 motions.
Just completely ignoring everything that was presented to him.
Yep.
As if it wasn't real, didn't exist. My
motion for temporary time sharing, docket number 35, which was filed by Rick Brown. July 24th of 2024 was dismissed without the hearing.
And that one really pissed me off, because the magistrate in his report says that temporary time sharing isn't even a thing in Florida. But Heather's attorney, who has 40 years of family law experience, filed it saying it is.
Yep. July 24th of 2024. We've since come
across other things where it absolutely is a thing.
So we're coming into 2026, and July 24th of 2024, my second attorney filed this motion for temporary time sharing so I could at least talk to and visit with my children. But no. The Serlicks are paying people to hide my children from me.
Certainly what it seems like.
Mm-hmm. So April 10th through the 11th, the docket reflects the motion to vacate. I literally flipped right around and did the motion to vacate the general magistrate's recommended order. And wouldn't you know, that was denied by Upchurch. So that was my first of many appeals I did this year. So that appeal is 5D2025-1056. And then I also have a second appeal that ended up getting merged into it, which is irrelevant at this point, which was 1442.
And that was one of your
disqualify Upchurch. Well, she's gone, so that's irrelevant now. But the 1056 appeal is still sitting pending in front of the panel of 3 judges at the District 5 Court of Appeals in Daytona, Florida. So that was April. Now, around April, what did I start doing with the national movements?
Started connecting with them.
Mm-hmm. I started connecting with a lot of people all over the nation.
And it was really about that point where we started to see how big of a problem family court really is.
April 2025 was absolutely our reality check on how bad the family courts are with these 2 to 3 page temporary orders that bypass all normal procedures like a TPR, which has to follow very strict procedures.
TPR is termination of parental rights.
Right.
Most states have actual procedures. There's specific hearings and specific findings and specific procedures that courts have to go through. But the family courts seem to ignore that completely, and they'll sign off on these orders that either just, give 100% of time and decision to one parent over the other, effectively terminating the other parent's rights, or as we've seen even here locally with another parent, the judges are filing temporary orders of protection.
Yeah.
Which
and
then
blocking
block
any
the
known
parent
contact
from,
with the children. And I've never, ever, as many times as I had been able to do that, I've never done that to Justin. Not once. But there were plenty of times where the state tried to, and then I would bypass the state.
And what we've seen happening with these temporary orders is if there's originally an expiration date, as that date gets near, the judge just extends it, sometimes for years.
Yeah.
Sometimes
So
they'll put in that it's
order
temporary
becomes
until
permanent.
Temporary until the children turn 21.
Yeah.
I mean, it's just...
Yeah, so in the end of April, that's when I really started getting connected with a lot of these larger groups. Phoenix Kai Rising, her group introduced me to ChatGPT custom cloning of our cases, which has been a godsend for me. So
just to keep track of everything.
Yeah, it really helps. It's like a legal secretary for $20 a month. You upload your dockets, and then you just say, what happened on this date? And it'll literally just spit it right out. Mm-hmm. So, and then you can share the link with anyone. And they can then say, give me a detailed summary of Heather Bendl's case. And it will literally tell you everything based on my dockets that are uploaded on the back end. Yeah. It's genius, and everybody should be doing it.
If you upload all of the court orders, you can, down the road, if you're like, well, what did the judge say at that last hearing? And it'll pull it up.
Yeah, it literally for $20 a month becomes your legal secretary. So it's a great tool to have in your arsenal. So beginning of May, that was my very first episode on Slam the Gavel with Marianne Petrie. Yep. So that was me really starting to
that was the first time
grow into my voice.
I was going to say that was the first time you really told your story in to an outsider in one full session.
Yeah, and it was a lot that I threw at her that day, but she gets thrown with a lot every day when she's doing her podcast recordings. I highly, highly recommend you go on her podcast. Marianne is amazing, and we need more of her doing what she's doing, and that's why Pete and I in 2026 are going to step into those roles.
With Marianne, if Heather will put the link in with this podcast. Make sure you go support her, listen to her podcast, share her podcast, her website. She also writes some books. Mm-hmm. She is doing an amazing job at really documenting and telling people's stories on what happens in family court. And it is really, if you don't understand what's going on in family court, listen to some of her podcasts, and it will give you a pretty clear picture.
In my opinion, listen to Marianne Petrie as a victim standpoint / advocate. Then pair that with the Judgmental podcast with Christine Miller and Hugh Barrow of Louisville, Kentucky. And then you'll get two attorneys' point of views on family court.
And these are not two attorneys that say everything's great.
No, they are whistleblowing.
They would rather tear family court to pieces at this point, is what it seems like. Their intro says they're trying to save the system, but I don't think the system needs saving. I think it needs a full tear down.
It needs to be burnt to the ground and rebuilt from the ashes up. So, moving on to May. I had an order denying the motion to vacate, which is reflected in my docket. So that was then turned around and appealed with a notice of appeal. So that was May 9th that I got my second appeal in. That was my motion to vacate the April 27th order here in Florida. Yeah. So I attacked it here in Florida in May of this year.
So one thing that it was sort of pointed out to us early on in 2025 as we were, really toward the end of 2024, what was explained to us was the UCCJEA Act, which has been adopted by 49 of the 50 states. So they all have literally the same exact wording in the statutes.
Yep.
So Illinois and Florida have literally the same wording in the statutes. They just give them different statute numbers, but it's the same content, same rules that they're both supposed to follow. And the UCCJEA is the law that tells courts how they're supposed to interact with other courts when you have child custody crossing state lines. Following the specific rules for the UCCJEA, it became blatantly apparent that those rules were not followed in Heather's case.
So our friend Beth had ran my children and I's timeline, chronological timeline of what happened and when and where. So the who, what, where, when, why, and how. She ran it through LexisNexis, and LexisNexis literally pointed us into the direction of Illinois didn't have jurisdiction to sign that April 27, 2022 3-page order that Justin Serlick is hiding your children behind.
And as we've dug into it deeper, they lost jurisdiction like 5 ways from Sunday.
Yeah. So we pivoted, and I filed the motion to vacate that 3-page order here in Florida based on that.
Florida has current jurisdiction.
They've had jurisdiction since February of 2022. Whether the Serlicks like it or not, they had jurisdiction the moment I transferred my Illinois driver's license to the state of Florida.
And the children had been in Florida for more than 6 months.
I bet you never expected me to tow my RV down here and transfer my driver's license, did you, Mary Serlick? I outsmarted you. So yeah, that changed everything.
Yep.
When Justin became a Florida resident, my children were residing here for more than 6 months, and then I became a legal Florida resident. Illinois lost any and all ability to do anything regarding my 3 children.
Over the 3 youngest children. Now, what we've since come to realize is there's also a problem with Illinois' jurisdiction over Heather's oldest daughter,
Ariana,
who at the time was refusing to travel to Florida. So she
refused to go live with her father.
Staying in the foster system in Illinois. Here's the thing. In Illinois, they're different from other states. Illinois actually has 2 different court systems. Juvenile dependency court, which is completely separate from family court. Juvenile dependency court is the court that hears CPS, DCFS related proceedings. The statutes in Illinois, if there is a juvenile court proceeding, that court has jurisdiction.
Yep.
Family court, even if a family court proceeding had started before the juvenile court, family court loses jurisdiction while that juvenile proceeding is progressing.
So in that 3-page order where they reserved Ariana to Justin and I both,
they literally did not even have
they
did not even have the jurisdiction to issue that order reserving the rights because she was still in the foster program. The issue there was she still had the open juvenile proceeding. It wasn't concluded.
And it was only open because Ariana was fighting to keep it open because she wanted nothing to do with Justin Serlick or the state of Florida.
So literally,
she wanted to stay up in Illinois where her friends and her school was. And I fully supported her because
you were telling the judge to allow her to emancipate.
Yeah, she wanted to emancipate herself, and I was in the same position at that age. I came very close to emancipating myself from my mother at 16 years old, 17 years old, and ultimately I chose not to take care of my grandfather who was disabled and dying. So I knew that if I emancipated myself, I was going to be kicked out of the house. But I also knew that if I got kicked out of the house, no one would take care of my grandfather and he would pass away. So I chose to stay for my grandfather. And so I figured if I did my job and I raised a strong young woman that I believe Ariana to be, then she would be successful emancipating herself and being happy and healthy up in Illinois where her entire support system was. But Justin was having none of that. He dragged her ass down here against her will. I will never forget the day that she was in that Zoom video with Judge Matthews, Reginald Matthews, and she buried her face in her foster mother, Christine Hart's chest because that was how terrified she was to be shipped down to the state of Florida to live with her abusive father.
Yeah, and it's all in the actual court documents that that forcing her to Florida fully originated
from
Justin and his attorney.
Had nothing to do with me. So May is when I really got my voice and started getting loud. And then we moved to June. So what happened in June? Do you remember the first weekend of June?
Well, we tried to take a little vacation, but before we could go on vacation,
well, so
you got...
the first weekend of June was my first taste of Facebook suppressing me. There was the first of, I think, three. We had 3 total national protests this year for family court and CPS corruption. And the first one was the first week of June. I was highly advertising Tanawah Downing, Jessica Saxton's protest in Washington, D.C. I actually was thinking of going, but I ended up not having the time to because of my court case. But I was advertising their protest in D.C. at the National Mall, and then I lost my Facebook for the entire weekend. It just poof. All of a sudden, Friday afternoon was suspended, and then I didn't get it back till Monday. So the whole weekend of the protest.
Monday, it pops back up like nothing happened.
Right. Yeah. So June 9th, docket reflects the 5th D2COA appellant case acknowledgement and indicates no new appeal will be created from a May 12th notice of appeal. So that's stemming from that May notice of appeal. And then June 18th. This hearing is on my YouTube channel under the Florida hearings. This was me standing my ground. I had to physically go in front of child support hearing officer Neil Kaufman at the Daytona courthouse, a tiny little room where I am sitting next to attorney Alan T. Holt of Florida Department of Revenue.
And 2 or 3 other people that they never identified who they were.
Alan is a coward.
Never
Holt
even looked over at Heather.
Could not look me in the eyes. He's literally sitting there shaking his foot and looking at the floor the whole time and mumbling.
Now, what was interesting...
I sit down and I put an entire stack of papers. I covered the whole table with all the exhibits of everything I want to talk about to show why they should not be enforcing this contempt order and attempting to take my driver's license.
It was almost funny because you spread everything out, and then when Neil Kaufman starts the hearing, he goes like, is there anything you want to say? And you're like...
I literally go like this.
Do you not see this table here?
You can see it in the video, and the video is the actual Florida Circuit 7 video footage that is available to the general public for $20.
But
I get those hearing clips, and then I put them on my YouTube channel immediately.
Yeah, the other thing about that is, this was one of the hearings where we really, the hearings with the judges and general magistrate up to this point, you don't know if they're really following the law or if they're just being jerks or ignorant or not. But the child support hearing officer, who is not a judge, I think he's the same level as a magistrate. He actually did put his name in for contention to be appointed a judge, but they denied him. That's how bad he is.
Yeah, he's a moron.
So one of the points you brought up, because the last time you had a hearing in front of Upchurch, we didn't know all the details about the jurisdiction yet.
Right.
So you
this
started.
Was my first chance to actually say no.
This was a new issue.
UCCJEA.
So this was a new issue you were attempting to present, and hearing support officer Neil Kaufman and the attorney for the Florida Department of Revenue, Alan Holt, were sitting there trying to pretend that you've already presented this information to a judge, and they were completely ignoring it. But then the other piece of information that you were trying to tell them is, guys, by the way, this child support order that you're trying to enforce has never been registered in the state of Florida for child support enforcement.
For UIFSA.
And then they try to pretend that they've never heard of UIFSA. And you're like, well, how the hell are you an attorney for the Department of Revenue, and how the hell are you a child support hearing officer? Yeah. And you've never heard of the law that allows child support between states.
That has been the go-to for Sandra C. Upchurch, General Magistrate Alexander Alvarez, child support hearing officer Neil Kaufman, and attorney Alan T. Holt. I'm not familiar with that. I don't know what that is. Yeah. What is that? What is UIFSA? What is UCCJEA?
They're trying to plead ignorance.
Yep. They're trying to make themselves look ignorant to the law. This is literally their job.
These are the statutes and the laws that are relevant to their job, and they're pretending like they've never even heard of it before.
Yeah. They're pretending they're ignorant to the law because
so asinine.
They have already been paid off to steer the situation a certain way. And it is so incredibly obvious that you don't even have to have an associate degree to see the connections here. Yeah. It's ridiculous. These people think that they can get away with this crap. It is very clear they're used to thinking that U.S. citizens do not know their rights and do not know how to stand on their rights. And this is nothing short of fraud upon the court under the color of law.
Yeah.
Fraud upon the court under the color of law.
Because as we have also since found out, how the courts are making money off of all of this.
Yeah. So this year we also learned about Title IV-D and Title IV-E. D is child support through the Social Security Act, and E is for foster and adoptions through the Social Security Act. So anytime you have CPS involvement, it probably more so leans on federal funds from Title IV-E. But if you're also forced to pay the state child support, then they're also dipping into Title IV-D. Yeah. If you're just dealing with child support issues, then it's going to go under Title IV-D. But they all kind of play together with the funding. So I didn't know anything about those Social Security Act extensions until this year.
It's basically a federal ATM for the state courts and child protection agencies.
Yep. The June 18th here, I believe it was the 18th. It was either the 18th or the 13th. So mid-June. And then for Illinois, because I was in appellate court at that point, and I knew that I was going to be moving on to appellate court with other motions in Florida Circuit 7, I had filed for an application for a fee waiver and costs of my Illinois docket.
Yep.
And when that occurred on June 11th, I filed the waiver for court fees.
And the clerk of the court told you this will be a couple weeks and eventually somebody will be in touch with you.
But wouldn't you know it, less than 24 hours later, after filing that fee waiver application.
You got an email in the middle of the night. Or a text. No, it was a text message.
No, it was an email saying the Judge Manick in Illinois Circuit 19 can see you tomorrow. And I'm like, well,
judge you've never heard of.
First of all, I've never heard or seen Judge Manick. She's not my judge. Second of all, why am I getting a direct email from the judge and not a clerk saying, we'll assign you to your judge on this date? That's the proper procedure. You're supposed to get a date for the hearing for the fee waiver.
It was definitely something was off about it.
Mm-hmm. And then, so we log in the next morning. Yep. This was right before we were leaving for our summer regional. To go across the state.
A meeting from my job, but it's basically a nice, restful vacation.
It ended up being 45 minutes of interrogation of Judge Manick interrogating Pete and I.
And here's the thing.
45 minutes of interrogation.
She was trying to make it seem like Heather was asking for hundreds of thousands of dollars worth of work product and material to be given to her for free.
I just wanted a certified copy of my Illinois docket.
Which, as we have now found out through filing your appeal in Illinois, we know about what the cost would have been, except actually it would have been less.
It would have been a lot less because I hadn't filed that 300-page petition. It would be like half
the. So we're talking about maybe $150 total is what the clerk would have charged. That doesn't mean that's what it would have, cost them to actually prepare this.
Yeah.
But the judges, again, she's questioning Heather about Heather's income. About the application Heather put in, which was all valid. There was nothing on there that wasn't true. Heather had, according to the statute, Heather had full legal right to file the application.
They're literally supposed to just ask you 3 separate questions, and based on your answers, approve or deny the fee waiver.
And then when the judge...
That's it. It's not supposed to go on for 45 minutes. They're certainly not supposed to be interrogating you.
Yeah, and when this judge realized I was sitting next to you in the same room, she demanded that I come on camera. Then she started questioning me about my income. And I'm like, hold on a second.
We're not married.
We're not married.
Just because we live together and we're engaged doesn't mean that you get to interrogate him on a court case that has nothing to do with him.
So it eventually, it was clear that this judge was just completely off her rocker and was most likely instructed to
make it go away.
Shut it down, make it go away.
Make her go away.
So Heather eventually in that hearing just shut the camera down and we left. We went on vacation.
Yep. So that ended up going nowhere. It was 45 minutes of evidence that I can now go after that judge as well.
Yeah.
So moving on to July. So July 2nd, I get from the 50CA the dismissal of my appeal for the motion to vacate the Illinois 3-page order. And in that dismissal, it literally said we lack jurisdiction.
So the state of Florida is saying that they don't have jurisdiction to vacate it. Okay.
So
well, what are you supposed to do?
What do you do next? You go to the court
original
that
jurisdiction.
Signed it.
The original court.
So from that point on, July 2nd, that told me, all right, time to go to Illinois Circuit 19 with this 3-page order. And now I have proof that Florida is refusing to deal with it from the appellate court. So awesome. I have more evidence to give Illinois Circuit 19 that Florida won't deal with it, so therefore Illinois needs to deal with it. So I started researching using different softwares, including Westlaw Classic and Westlaw Precision AI. As a certified paralegal student, I had access to several different softwares, actual legit legal softwares that attorneys use and are not cheap, like Westlaw, to do some research. So I started researching how I could get this dealt with in the state of Illinois. And that's when we found out that Illinois has a specific statute that allows you to attack void orders at any time. So July 17th of this year, I filed my petition for relief and vacature of the April 27th, 2022 Illinois Circuit 19 order under that specific statute. And then July 21st, here in Florida, because I was attacking it from both angles, I also filed my writ of prohibition in District 5 Court of Appeals.
Yep.
And I spent over a month putting together that legal document. It was I thought, very well done.
But
and it sat for several weeks.
And as we've found out, most appellate courts just deny writs of prohibition.
Although
by default.
On the Judgmental podcast, Christine Miller and Hugh Barrow have been talking about these extraordinary writs and how they previously had never seen. It was very rare for the appellate court or the Supreme Court to ever grant them.
But now they're seeing them a lot more. In
recent years, they're starting to actually be approved more often because, and I believe this was the exact words Christine used on the podcast, the family court lower tribunals are being so egregious with what they're doing that now these writs are actually being approved. Yeah. So moving to August. So my docket reflects the motion to dismiss. So in August, now we've got Alan Holt motioning to dismiss my motion to vacate the child support hearing officer. So here's Alan Holt trying to assert himself into my court case. And
which here's the interesting thing.
He didn't even show up to the hearing.
Going back to the actual fact in your case that the original child support order from Illinois had not been registered for child support enforcement in the state of Florida, Alan Holt has zero jurisdiction to even be present and be attached to this case in any fashion.
Yeah. He's going to get a nice little awakening in 2026.
U.S. Marshals are on the way, buddy.
August, notice of hearing appears in the docket stream. Record on appeal. My record on appeal for the first appeal here in Florida District 5 was sent over. And then for my writ, Florida District 5 denied my petition on August 14th. And sorry, that is my Libre sensor screaming at me. It's about to end. Get rid of that. And then I filed on August 18th, 4 days later, a motion for written opinion and rehearing, which they denied, which that means, so for anybody that doesn't understand what it means when they do not give you written opinions, when appellate court does not give you a written opinion, that makes it almost impossible to move it up the chain of command to the state Supreme Court.
Because you have nothing to argue.
Exactly. So you always want to file, this is not legal advice, take it as you will. You always want to file a request for written opinion, because if you then, like in my case, I'm going to turn around and file this writ of prohibition in Florida Supreme Court, I can then say, I requested a written opinion and then they denied my written opinion. on August 18th.
So
So I need Supreme Court to step in, Tallahassee. Come on.
Speaking of written opinions, something else we found out this year. So for anybody that's still in the trial court or lower tribunal, whatever you want to call it, especially with child custody related cases, there are times where the judge is actually required to issue findings and opinions. And there's some times where those are required to be in writing. And I can't tell you how many times in Heather's case, the judge has just, signed off on an order with no actual findings on it, just denial with no findings. And
it's deny or dismiss.
There's a couple times when we go back to research what we can do, and the answers we're getting is that judge just violated the law by not issuing any actual findings or opinion on that particular matter that you had motioned.
Yep. So, so now we move to Illinois. So August 12th was my very first hearing in regards to that July 17th petition for relief and vacature of the 3-page void order, where attorney Will Traberis of Katz, Goldstein, and Warren showed up without a notice of appearance. So I called him out on that on August 12th, and Judge Melius, Jacqueline D. Melius of Illinois Circuit 19,
just kept going.
Just let him continue talking, even though I pointed out there was no appearance on record, which was
nothing was filed in the docket.
Illegal. Until there's a notice of appearance, you cannot speak on behalf of that client. Yeah. You can't. And Justin wasn't there. So that literally means Justin was not there and did not actually have proper legal representation on August 12th because I was calling him out on it. After the fact, that notice of appearance ended up showing up in the docket later on.
And dated for August 11th, but it absolutely was not there on the 12th.
Yeah. It also was not there September 2nd because I called it out once again on September 2nd.
And it showed up after that.
Yeah. So then I get this response to order to show cause / objection that Will Traberis filed in. And then, let's see.
What's interesting is that the objection that he filed was objecting to Heather filing this petition because
that's right.
The Illinois court didn't have current jurisdiction because jurisdiction had been transferred to Florida. That was the argument. And we completely agree with that argument, but it goes beyond that. We know the fact that the Illinois court did not have jurisdiction when they issued the underlying order from April of 2022.
The fact that both of these courts are completely ignoring everything I'm putting in front of them is without a doubt proving my theory that this has all been bought and paid for and bribed since day one. Yeah. And everything I've been screaming from the rooftops is true and accurate because there is no way with the amount of kicking and screaming I have been doing all of 2025 is being ignored if that's not the case. It is so obvious that Mary and Ira Serlick are controlling everything that is happening between Illinois and Florida.
The other shocking thing is that these courts have absolutely no inclination or desire to correct themselves when you point out the errors. And I mean, these are just blatant. These are on paper errors.
Because they have a God complex. They put on that black robe and they become God in their eyes and in their view. They are above U.S. citizens.
And then what they try to do to pass it off, and I know other people have run into this. Heather's run into this. So how many judges have been attached to your Illinois case?
Over 6 now. And none of them left because I disqualified them. They literally do something nefarious in my case and then dip out and reassign it. Yeah. It is become so clear that that is their MO.
So
they do something illegal and nefarious to mess up a citizen, and then they dip out, peace out, and say, okay, it's your problem now, and now you're just going to go ahead and say, well, I wasn't judged for that, so I'm not dealing with it all.
So 6 different judges in Illinois.
Since 2020.
2 judges, a general magistrate, and a hearing officer here in Florida.
And have I had any contact whatsoever with my children at any point in 2025?
In 2025, none. other than, well, we don't know if you were actually communicating with your children, but there was a couple text messages, like back and forth text messages that were supposedly your daughter Bianca, but the messaging was
so
strange, to say the least.
Yeah. So it's insane that I am going to the lengths I'm going just to see or speak to my children on the phone, and I still have zero contact with them.
And that's one of the things that, people who haven't been through this may think this is strange, but the reality is, in Heather's situation, because I've seen this firsthand myself, Heather will get messages that seem to be potentially coming from the kids. But then when Heather will ask a question that the kids should know an answer to,
they can't answer.
And then when Heather,
where it becomes obvious that it's Mary Serlick or Laura Stiles pretending to be my children.
And then you'll try to either have that whoever it is communicating with you do a phone call or a FaceTime, and they refuse.
Mm-hmm. Yeah. Because the whole thing is being controlled by Mary Serlick and Laura Stiles.
It's what it seems.
So this August 12th converted to September 2nd. September 2nd, because the August 12th was just a presentment of my petition. Okay?
Because Illinois does stuff weird.
Yeah.
It is so inefficient.
September 2nd was supposed to be the first summary hearing, and it was agreed that Justin Serlick and I would be remote. Melius required us to be in person. Will Traberas argued that Justin couldn't be there in person, so that I then responded, okay, well, if Justin's going to be remote, I'm going to be remote. He works remote. He can drop everything and fly up here. I'm a public school teacher. It's a lot more complicated for me to take time off and fly up to Chicagoland. And let's not forget that ICE has been attacking Chicago all of 2025. So it's not exactly something I want to be around.
Well, and then the other thing, and we pointed this out on our last podcast, is this wasn't even an actual hearing. It was just sometimes it's called motion hour, where you might get 5 minutes with the judge. But the judge was requiring Heather to travel to Illinois in person for this 5-minute meeting. Mm-hmm.
Which would mean every other hearing would be in person. So I'd be constantly flying back up there.
A month later, you would have had to fly back again in October. Yeah. And then 2 months later, you would have had to fly back up there in December.
Looking back now, it was obvious that they were trying to use that as a detour.
Hurdle.
They were trying to make it a hurdle so I couldn't move forward with my petition. Now, if my petition didn't have any merit, if it was frivolous and didn't have any merit, why did they start going to the extremes they went to? Because September 2nd in the hearing, which I have recorded, so I have evidence of what was said, it was agreed upon that all parties would be remote. September 23rd, very late in the day, like 5 or 6 p.m., I get a blank email from Clerk Iris Salcido, who is Melius's clerk, with a blank email, no subject line, no body, and it's an order dated September 2nd, but emailed to me on September 23rd.
More than 20 days after the hearing, after the document is dated.
Yep. Telling me that my Zoom is revoked, and only my Zoom, and I have to then be in person, October 8th.
With barely a week to arrange travel.
And as I previously said on my last podcast episode, and then as well as recently Pete and I were on Slam the Gavel, Marianne Petrie's podcast again, that order, when it was emailed to me in the blank email, terrified me. Because it became so obvious it was a setup to get me in person in Waukegan, Illinois, at the Lake County Courthouse to throw some bogus contempt order on me and put me in the Lake County Jail. Yeah. I don't care if you believe in conspiracy theories or not. It was all arrows pointing to that.
It was so outside of normal rational procedure that it raised every red flag it could have raised.
Yeah. Yeah. So obviously October 8th, I'm remote. Took me over an hour to get into the hearing where they said, we dismissed it because you're not here in person.
But what's interesting, you forgot something. You actually filed some stuff with the court before that October 8th hearing. You filed an ADA accommodation request.
I did. I filed it. It's not on my list here. Yeah. So in response to them ordering me in person with that mysterious September 23rd email, I filed a American Disabilities Act. Number one, I'm deaf in my right ear, so I need Zoom so I can hear appropriately. Number two, I'm a domestic violence victim, and this court is my abuser, and Justin Serlick is my abuser, and I'm protected under ADA for that as well. So there are quite a few ADA violations that Illinois Circuit 19 and Judge Melius has violated that I'll be going after her in federal court.
Judge Melius acknowledged in her order that you filed that ADA request.
And did nothing about it.
Instead of actually acknowledging the ADA request and making sure the accommodations were in place, she denied it with the claim that, or the reasoning that you did not send the court courtesy copies.
Yeah.
So let me explain something. And I'm not a lawyer.
Doesn't care about courtesy copies.
I'm not a lawyer, but I'm sure there's ADA lawyers out there that might be interested in this. The Americans with Disability Act is, again, I'll say it again, it's a federal law. The U.S. Constitution has what's called the Supremacy Clause, which means federal laws supersede state laws, local laws, court rules. So Judge Melius's rule that you have to submit courtesy copies does not excuse her from the legal requirements to accommodate the ADA request.
Right.
U.S. Marshals are on their way.
Yeah. So I immediately, after that dismissal, within 2 weeks, filed that notice of appeal. And my appellant brief is due January 12th of 2026 on an accelerated timeline under Illinois Supreme Court Rule 311A. So that is now in Illinois District 2 Court of Appeals, and we will be moving forward with that at the beginning of January 2026. September 7th of this year, I organized a local protest at the Daytona Courthouse and the Daytona Court of Appeals. There was at least 5 or 6 of us there. And whether it's connected or not, it's too coincidental to ignore. 2 weeks after that protest, Sandra C. Upchurch was moved out of Daytona, off of family law, and into Flagler County. So she's still on the bench in Florida Circuit 7, but she's no longer on family law, and she's no longer at the Daytona Courthouse. So I now have a new judge. I cannot pronounce her.
Literally a brand new judge.
Yeah.
Has just been appointed by Governor DeSantis. She was a former state prosecutor, so she has not practiced in family law as much as we can tell, because she was a prosecutor in the criminal court.
I wish I knew how to pronounce her name, Judge Randall, and she goes by Randy.
D'Agostini.
Yeah, it's
how it's pronounced.
DAUGUSTINIS. So
Augustini's.
Yeah, I don't know.
But we'll find out.
Because I have been focusing on my Illinois petition since July, I have not filed anything in front of this new judge that replaced Sandra C. Upchurch, because I kind of wanted to see where things were going to go with this beforehand so I could be better prepared for what I wanted to file in front of her. Yeah. But I can tell you this, I will be filing something, at least 1 or 2 things in front of her January of 2026. So basically what I'm doing is I've got my appellant case going in Illinois Circuit 19 and now into District 2 Court of Appeals in Elgin, Illinois, which is Kane County. Then I will be filing some new motions in front of this new judge in Florida Circuit 7, while my 3 appeals from earlier this year are still kind of working its way through District 5 Court of Appeals. If my District 5 Court of Appeals stuff goes nowhere, I will be filing a writ of prohibition in Florida Supreme Court directly with Tallahassee next. And then I kind of want to give myself a soft deadline of March 2026. I want to have my U.S. District Court of Orlando 42 USC.
Middle District of Florida.
Well, it's in Orlando. Middle District of Florida in Orlando. So that's federal court, U.S. District Court. And that is going to have all the defendants here in the state of Florida that are currently harming my children and I. Everyone down to Mary Serlick and Laura Stiles.
Literally.
No one is going to be left off. There's going to be plenty of love. Mary Jane Nettles, Rick Brown, Serena Baldacchino. You're all going to be named.
Yeah. And literally at this point, I mean, the overarching constitutional violation is violation of your parental rights.
Due process.
Troxel
v. Granville.
But
Morgan v. Morgan, where if one parent is holding the children hostage, the other parent does not pay the ransom during that time they're holding them hostage, aka child support.
But then also the collusion that's been going on. Yeah. And I say collusion because there's literally
these people are all committing felonies.
Emails of people that have no business being tied in with your case they're inserting themselves, creating more havoc. I mean, you've literally had your ex-mother-in-law had emailed the judge in one instance. You have other people.
Her and Laura also emailed Sheriff Mike Chitwood.
Yeah.
He's going to be a defendant.
Yep.
Anyone that has touched my children and I's case here in Florida will be a defendant. Anyone that I'm aware of. So we're talking Mark Weinberg. We're talking Joshua Griffith. We're talking Chief Judge Leah Case out of Daytona. I think she's in Daytona.
I have no idea.
I don't remember, but she has been CC'd on almost all of my emails, and I have plenty of read receipts from her and her judicial assistant.
Yeah, I don't.
So Leah Case is supposed to be managing her lower judges, and obviously she lets them run rampant.
It's apparently now questionable on how much authority and oversight the chief judge actually has, or whether it's just a title and name only.
The read receipts prove that she knows what's happening in my case and is doing nothing.
Yeah.
So that makes her an accessory to the 85 and 86.
Yeah, and a bunch
conspiracy and known that violation of civil rights is happening and doing nothing about it. So she falls under 85 and 86.
Yep.
So everyone is going to have U.S. Marshals serving them.
And you know, I know here in Florida. I know I joked a little bit about the U.S. Marshals are on the way. It's not that the U.S. Marshals are showing up to arrest these people, even though
they're going to be serving them.
When you are filing in federal court, if you are meet certain requirements and file a certain way, you get the courtesy of the officers of the court, which are the U.S. Marshals. They will essentially act as your process servers to serve the federal lawsuit to the parties involved.
So 2026, Ira Serlick's going to be served, Mary Serlick, Justin Serlick, Laura Stiles, Upchurch, Alexander Alvarez, Neil Kaufman, Alan Holt, Sheriff Michael Chitwood for his involvement with the emails that I got from Volusia County Sheriff's Office, Rick Brown, Mary Jane Nettles, Serena Baldacchino, Paige Russo, and there's more. But that's just who I can name off the top of my head. I'm going to have fun with this. This is going to be fun. So, and then later in 2026, I am going to turn my sights on all the Illinois players, which is a much, much larger defendants list. Because I've been building that Illinois case in federal court since my children were kidnapped October 8th of 2020 from Kitty Cottage Daycare by Jessica Lyman of Waukegan DCFS. And
with no court order.
Yeah. So Camelot Care,
no ID, no
Elizabeth
business card.
Tevis, Kayla Davis, Scott Cox, my attorney Thomas Hunter, Oren Grappe, Justin's attorneys, Mary, Justin, and Ira will be defendants in that one as well in Illinois. I've been playing this out in my head for 6 years now, guys. This started in 2020. And we are just a few hours away from 2026. And this has been 6 years of me planning and building this case. And 2026 is the year that I pull the trigger.
And let me just say, I've known you for almost 3 years now. And in that time, everything that you said you were going to do, every goal you've set for yourself, you have done. And so all of these people, their time is coming.
Happy New Year, everyone. You're going to have a great time in 2026 with me. To my children, Ariana, Tommy, Bianca, Charlie, this is what I've been doing all of this year, just trying to talk to you on the phone. Boxes and boxes of court documents I have been filing, writing, drafting, filing, standing on my rights, demanding to see and speak to you. All because Justin Serlick is hiding you guys from me while collecting almost $1,800 a month from me since September from my teacher's salary. $870 every 2 weeks has been deducted from my teacher's salary since my second paycheck in September of this year. So he has collected in 2020 between the $1,000 purge payment and the wage garnishments over $6,000. And I haven't even had the courtesy of talking to you guys on the phone for your birthday.
Or Mother's Day or Christmas.
None of the holidays, nothing. It's like you guys just don't exist. While he has collected over $6,000 from me this year, stealing from me. So while he has been stealing from me and neglecting your education, your mental health, and I'm positive your physical health, I have been fighting with everything I possibly can between Florida Circuit 7, Florida District 5 Court of Appeals, Illinois Circuit 19, and now Illinois District 2 Court of Appeals, just to speak to you on the phone.
Yeah. And
so I would love someday for you guys to tell me what is really going on here. Yeah. This podcast I started doing in March of this year in hopes that someday all 4 of you will see these videos and you will see what's actually going on, because you are being lied to, and you have been lied to since 2020 when all of this began.
Yeah, and
6 years of fake truths, of lies, of manipulation, parental alienation. You are being neglected. You are being abused. You are being used to collect money. That's all you are to Justin, Mary, and Ira Serlick, is pawns to be used to collect money. They do not care about your best interests. They do not care about your welfare, because if they did, you guys would be doing a hell of a lot better in school than you are. And I'm a public school teacher here in Florida. So you can only use the excuse of it's Florida schools for so long before it becomes it is a neglect problem. And this is me fighting to bring awareness to what is happening to you for. So in some way, shape, or form, I can get you the help you desperately need, because it is obvious you guys need help. And I love you. I miss you. And I will never stop fighting for you. In 2026, I take it to federal court.
Yeah. And
I hope that anyone that listens to this, if my story resonates with you, if you're experiencing something similar, I hope that you start educating yourself to the point where you feel confident that you can be a pro se litigant and join this national movement in federal court for 42 USC 1983, 1985, and 1986 complaints. And along with those complaints, I'm going to be putting a section in that I am requesting and demanding that an investigation into my case and all the defendants involved fall under 18 USC 241 and 242.
Yeah, and what's interesting is, in the last couple days, there's been, massive sort of internet outrage and public attention that just got drawn on
Minnesota,
the fraud occurring in the with the daycare payments in the state of Minnesota. And the reality is, once you dig into what's been going on in the family court and CPS systems across the country, the greater fraud has been occurring tied into the family court system. We're talking about billions, if not trillions of dollars at this point for decades of fraud that the family courts have been pursuing by stealing, children from one parent, giving them to the other, completely locking parents out of their children's lives, taking children from homes where there was no neglect or abuse and putting those kids into foster care, all just so they can get federal subsidy payments through these programs.
Title 4D, Title 4E. Now, I've known probably since 2012 that child care assistance is abused. Before I got my kids in public daycare, I was always highly against public daycare as a younger mom. And for the first 3 years, I was a stay-at-home mom. I didn't go back to work until Ariana was 3 years old. So I was a stay-at-home mom for 3 years with Ariana and Tommy. I had always felt, and I feel the opposite now, but I had always felt that private in-home daycares were better for children. And my daycare provider happened to live on our street in Fox Lake, Illinois. And I started to figure out that she was actually putting longer hours than my kids were actually in her care on the CCA paperwork. And when I questioned her about it, she gave me some weird excuse that that's just how they do it. But I figured out that she was actually kind of adding more hours than she was actually watching my children to get more money from the child care assistance. So this fraud that's being exposed in Minnesota doesn't even surprise me in the least. It is so common for even small daycares to do this stuff that for these businesses to create LLCs and then just pretend to be actually watching children is not far-fetched at all. So these programs absolutely need a full overhaul, and absolutely thousands of people need to be investigated. Yeah. This is a nationwide issue on fraud that's happening with all of these Social Security benefits and, the child care assistance and SNAP benefits. It's a very well-known fact that people sell SNAP and WIC programs, and it's insane. So with the Title 4D, I'm super excited in 2026 to see what the movement with Mark Ludwig brings, going back to DC again. I'm so excited for that.
So I think you forgot to mention that in our
I wanted to leave it towards the end because I wanted to lead into 2026. So
I know it's been on, we've talked about it on the other podcast, but in November you went to Washington, D.C. with a group of about, was it 20 or 40?
It was over 40 of us.
40 of you to seek
all
out,
with similar stories.
Seek out any congressman, senator, staff that was in their offices at the time.
Talk to anybody that was willing to lend a ear.
Talk about the problems with Title 4D and what some solutions might be, and how they could do their job and help. And it was impressive seeing the photos that you sent back and some of the videos and photos that some of the other folks had sent. It was impressive, and knowing you are definitely going to be going back on a future trip, and Mark is hoping to have bigger group of people next time.
Every time we go, we're hoping to double the amount of people. So by the time we get like 4 or 5 trips in, we've got over 100 people in DC.
Which here's
in the buildings.
That's good and bad. It's good that there's that many people that have the time, energy, and motivation to do that. It's bad because if there's that many people, there's that many people that have been abused and broken by the family court system.
There's hundreds of thousands of us. There's no doubt about it. There are hundreds of thousands of us in the same position as I am, in the same position my children are. And let's think of this in a long-term perspective here. As a teacher, I always kind of view what's going to happen with the generations. So what's going to happen with all these kids that have been abused by the system with these last two generations. When they are our age, do you think they're going to have good relationships? Or do you think they're going to be struggling their entire life with forming trust in
statistics
healthy
are
relationships?
The statistics show that the kids are going to struggle throughout their life,
Yep.
and then their kids are going to struggle.
We're literally going to have an entire generation of children, several generations of children and their children that are going to suffer because of the amount of people abusing Title IV D and E.
And just
for their own financial gain.
Family court and CPS system as a whole.
And that's why I believe it needs to be completely burned to the ground and built up from the ashes up, because I honestly don't think that there's any reforming this. I think we need a complete overhaul. But something has to give. Something absolutely has to give. And I agree with Christine Miller. She put out a podcast episode recently where she said, I believe 2026, something big is going to happen in family court. And I really think that if we continue to be loud, if we continue to tell our stories, if we continue to be transparent with our cases like I am, where I'm literally giving the entire world my docket to dissect and absorb, if we all show that level of transparency in 2026, they cannot ignore us forever. It will start to fall apart. It will start to crumble. If we demand transparency in the courtroom, if we demand that the states start actually passing laws where audio and video must be recorded and must be stored for X amount of time, and if you're concerned about minor children, make it only available to the parties of interest. It doesn't need to be available to the general public. But there has to be some sort of accountability for all these judges, for all these magistrates, for all these hearing officers.
Absolutely has to be some legitimate oversight that occurs, and right now that does not exist.
No.
You have appellate
the bar
courts.
protects their own.
Well, and you
the
have,
JQC protects their own.
You have appellate
They're
courts
all a big club, and we are not part of it.
No, and you have right now what's happening is you have appellate courts that are reversing decisions by these lower court family judges. And those family judges remain on the bench. They continue to issue bad rulings that violate the law, violate the Constitution, violate human rights. And
this is a human rights issue at this point.
And nothing happens to those judges. They keep on going. And then the appellate court gets another case that they overturn for the same judge, for the same reason. And that judge continues to sit on the bench.
Yeah. On that note, I do want to point out that Pete and I did just recently join Marianne Petrie on her podcast, Slam the Gavel Again. That was just 2 or 3 days ago, Sunday. So Sunday, December 28th, we were on Marianne Petrie's podcast again. So definitely check out Pete and I. My first episode with her was in May, and that was just myself kind of giving everyone an overview of my children and I situation. And then Pete joined me this last time, kind of explaining how we're whistleblowing, exposing, and advocating for real changes in this realm. So definitely check out that episode if you're curious to hear more.
And then after you check that episode out, also coming in 2026, we're going to be putting out some episodes for our other podcasts. I'm host of the Support Isn't Silent podcast, which is a podcast that tells the stories of partners and family members of the victims of family court. Heather has a separate podcast, separate from the Justice for the Serlick Children podcast. You have the Disrupt the Corrupt.
So
podcast.
That's going to be very similar to Marianne Petrie Slam the Gavel, where I'm going to have guests on that tell their story and get transparency out in their world. And so we wanted to start launching both of those podcasts in September. Obviously, as you can see, a lot has happened. Yeah. We've been very busy with health issues. And then, of course, my Illinois fight for this 3-page void order that Justin Serlick is hiding my children behind.
And on top of all of that, we have our regular jobs that we both have that we have to do to keep up with life. But the other podcasts are definitely coming. We have the guest list. We're going to be reaching out to them probably this week or next week
I would say after my
the initial
appellant,
brief.
yeah, after my appellant brief is due January 12th, then we can kind of start to have a little bit of fun with the podcast.
Before the end of January, definitely we're going to be getting some episodes recorded. My podcast is not going to be a live, podcast, but it will be video and or audio.
Yeah.
We have on the technical side of things, we have everything is set up. The Spotify and other podcast platforms are all set up.
Yeah, they're already on Spotify. Yep. We just haven't really done any guests yet. But I would like Marianne Petrie to be my first guest on Disrupt the Corrupt, and I've already spoken to her about that. So hopefully we can make that happen. Yep. But with that, I wish you guys a happy and safe rest of New Year's Eve 2025.
And a great New Year 2026.
I wish you a great 2026. And if you are a family court victim, a CPS victim, let's go federal, guys. Let's get this in U.S. District Court. Yeah. The more 42 USC 1983, 85, and 86s we have in U.S. District Court across the nation, the more obvious it will be that this is a massive issue across this entire country.
There's two things that will, really upend the system, and hopefully those happen. One is Title 4D reform. The other would be having an official record of all family court proceedings.
Yep.
That was one of the things that was shocking to us as we transitioned here to Heather's case into Florida, and the local courts in Florida. There is no official record of family court proceedings unless the private party pays. But even when the private party wants to pay,
at least $800 to $1,000.
But even then, when you try to reach out to the court to say, okay, I'll pay for this, I need
good luck finding one that will work with the pro se litigants.
I need the hearing recorded so that the transcriptionist can actually do it. Oh, no, we don't record family court proceedings.
Yeah,
that's the answer
because that is where the RICO comes in. They push you to these court reporters that charge you $800 to $1,000, but then ask if you're pro se. And the moment you say pro se, they won't work with you.
We don't work with pro se litigants.
Right. It's a massive RICO scheme.
It is.
And that's why attorneys like
ridiculous.
Matt Grant are coming forward with RICO filings in U.S. District Court. That's why attorneys like Connie Regularly and Christina Miller and Hugh Barrow are coming forward and exposing this as well. And hopefully in 2026, we have a lot more attorneys that are willing to come forward and expose this, because it needs to be exposed. We've got social media now. They can't hide from it anymore. They may have been able to in the 70s and 80s and maybe early 90s, but sorry, guys, the internet's here, social media is here, podcasts are here. Mainstream media may not cover it, but we can certainly get it all over the internet through TikTok, etc. So
with that,
join the fight and let's go, guys.
Happy 2026. Happy New Year.
Bye, everyone.